second accused had been charged with the offence of obtaining money by false pretense, contrary to section 313 of the Penal Code. On the date of plea taking, prosecution counsel Ms. Semo objected to the first accused, who is also a director of the second accused, being released on bond/bail terms. The prosecution counsel raised ground that the first accused was arraigned in court number 8 on the 13th of February 2025 in criminal case number E600 of 2025, where she had been released on a cash bail but absconded court. Further, a warrant of arrest was issued against her, and the matter was mentioned several times, after which it was withdrawn under section 7 of the CPC. It was counsel's submission that the first accused was released on a lenient cash bail but absconded court. Counsel Mr. Charana, holding brief for Mr. Danstan Omari for the first and the second accused, stated that the first accused had been released on a police cash bail and not a court cash bail. However, the first accused never took plea, hence the charges were withdrawn under section 7A of the CPC. Counsel also stated that it's the first time that the first accused was taking plea and urged for lenient cash bail terms. It was his further submission that the accused is a parent of 2 children, aged 9 and 4, and one of them has a mental issue that requires jabs every Saturday. On the very date, the court stated that no medical records had been availed to show that the first accused child has a medical condition and is expected to get jabs every Saturday. The court then reserved the ruling for delivery today. So the main issue for determination is whether the accused should be granted bond/bail. So the court looked at Article 49(1)(h) of the Constitution, Section 123A, and Paragraph 4.9. Section 123A of the Criminal Procedure Code, Paragraph 4.9 of the Bail and Bond Policy Guideline, which provide non-exhaustive factors to be considered in an application for bond. So in brief, I had the benefit of perusing court file number E600 of 2025, where the accused was indeed absent when the matter came up for plea taking in the first instance on the 17th of November 2025. And during that court attendance, the prosecution counsel informed the court that the first accused had been summoned several times by the IO and called to attend court on that day, but was still absent. So the court then issued a warrant of arrest against her, and the matter was set for mention on the 24th of November 2025. On 24th of November, she was still absent, and her counsel, Mr. Kareithi, informed the court that she was unwell. So the court then held that the accused was absent again, and though she had availed hospital notes, the same had not been availed the previous week. So the trial magistrate, then Honorable D. Allegro, Chief Magistrate, ordered that the order issued on the 17th of November be enforced and cash bail to be forfeited. The matter was then allocated, I mentioned it, for the 1st of December 2025, on which date she was still absent, and the matter was withdrawn under Section 7. So a brief summary of the proceedings in criminal case number E600 of 2025 shows that the first accused was aware of that case. This is due to the fact that during one of the proceedings, she had instructed counsel to act for her and inform court of her illness. The first accused counsel did not deny that she did not take plea. The first accused has also not shown steps taken in following up on the case, or at the very least, her attempt to make an application for the warrant of arrest to be lifted. So the issue of whether she had been released on a police cash bail or a court cash bail is immaterial, because the purpose of the police cash bail was to secure her attendance for the trial as provided under paragraph 4.4d of the Bail and Bond Policy Guidelines. So the first accused failure to attend court after a lenient police cash bail was granted, and her counsel's attendance in court in her absence demonstrates there not being guarantee that she will attend court if bail and bond is granted. So the court then also looked at paragraph 4.9d of the Bail and Bond Policy Guidelines, which provides that the failure of the accused person to observe bond on previous occasions is a good ground for denying bail or bond. In addition, the court looked at section 123A2 of the CPC and the decision in Republic versus William Kiporich Chiril and another 2018 EKLR. So in summary, the record in E600 of 2025 shows that the first accused did not attend court as required. There is therefore a likelihood she will abscond court if released on bond/bail, and relying on section 123A2 of the CPC and paragraph 4.9D of the bail and bond policy guidelines, this court finds that the prosecution has proved there is a compelling reason why the first accused should not be released on bond / bail. Accordingly, the first accused is denied bond / bail. She will remain in remand during the pendency of this trial. Right of appeal 14 days.
Much obliged. We can make an application for review of your ruling, considering that it is tried law that the issue of bail and bond, one can make an application for review at any time and as many times as possible. May I seek if the court can allow us to make an application for review?
Right now?
Right now.
I've just delivered the ruling, it's not even published.
The court has read.
It will be the grounds that you
allow us, Your Honor, to make an application, because it's very pertinent for the court to understand our point of view.
Thoroughly?
Thank you. Thank you.
Sorry, just a minute. Ms. Semo, do you object?
No objection.
We can proceed. You know, we make this application for review on the basis that for one to appear before a trial court, proper summons must be issued to the accused person. From the court record, there is no summons for the accused to appear before court. The investigating officer admits that he called the accused person severally. No evidence or material was placed before the court in form of call logs or call data to ascertain whether indeed the investigating officer summoned the accused by phone. On a third, the Criminal Procedure Code has no provision for summoning suspects by phone. This is a court of law, and the CPC provides for procedures for the police. It is by summons. On a third, counsel who held her brief is not the counsels now present. We have come on record, myself and Mr. Cliff, there is no evidence at all that summons were issued to that counsel of critical concern is that the state withdrew under Section 87A. In the celebrated case of Githunguri versus Githunguri, if the state withdraws a matter, there is a legitimate expectancy that the accused person is not going to be charged. A critical look at Section 87A is withdrawal either for further investigations it is not withdrawal for the purpose of closing that file and opening another file.
Please repeat.
The purpose of withdrawal under Section 87A is to either continue investigations, and if there is evidence to charge, it is in that same file that the state will charge. Here, Your Honor, one file was withdrawn under Section 87A. Another file was opened. It is my humble submission that the court will be able to read the mischief that the allegation that the matter was mentioned before the trial court with her absence. The court, we urge the court to reconsider that decision and grant the accused person conditions which she will comply. She's present now before this court. She has not defied any of the conditions of this court. And we urge the court to reconsider that decision in the best interest of the accused person and the mitigating factors that the court was told about a child who takes medication every Saturday. As the court tampers with the justice, we urge the court to look at the third party, who is the minor, who, if the minor loses its life, we shall be very sad, all of us in this court. Donna, kindly, you can review that decision. Mr. Ombeta will say one or two words to add on my submissions.
You know, probably I should also start with a bit of a sentimental part of it. You know, one of the things I've informed the court is that the accused person is a widow. And currently, the company that is charged alongside her was started together with the husband. It no longer operates. She's struggling on a day-to-day basis to be able to make ends meet. Look at her kindly. You know, this court, this lady or the accused person has not broken the bond terms of this particular court. Is it possible, Your Honor, for you to be able to give her a chance and give her bond terms and we test her by them? I believe it is possible. Is it possible for the court to give terms and conditions that are strict so to ensure that she comes to court? That one also I believe the court can be able to do. But Your Honor, probably water under the bridge, but then was the state able to prove that summons initially were issued to the accused person? The reason why we have these fundamental rules and laws is to protect such a person from the state and its excesses. The state might come here and tell you that they did it, but they also need to be able to prove to you that they actually did it. Your Honor, that she failed or did not present medical documents. Is it too late to be able to provide such, Your Honor? I believe that the court can give us time so that we can be able to produce and show that. Can we also be able to show that she has a sick child? If the court grants that particular moment, as you are considering this ruling, the documents can be availed. I believe the court can be able to be humane enough and be able to do that. Your Honor, under Article 28, there is the inherent dignity of a person. That she can be in custody while the child is suffering and the child is at home. Your Honor, I'd be able to ask the court, please treat her with some kind of dignity so that she can be able to go back home and take care of the child. Now that she's a widow, nobody else remains with the child. At least you can be able to accord her that. Your Honor, you definitely have gone through all these articles that you quoted on the sections and the bail and bond terms. But let us go back to Article 21, Your Honor, and Article 20, which binds the courts, the prosecution, the police, and other state organs. That once they have realized that somebody or the fundamental rights for a person exist, what is expected of the court, Your Honor? It is expected that the court would want to start by wanting to grant these fundamental rights to ensure that they are enforced. And we are asking the court, Your Honor, please breathe life into it. It is not only that incarcerating the person that can be able to ensure she comes to court. Your Honor, in the case of David Richard Alden, case number 48 of 2014, before Justice Lassit, the court said that the worst case scenario, what would it be? It is not only by ensuring the person is denied bail, but by the court putting terms stringent to ensure that the person appears. It is the same ruling that came in the case of Dwight Sagarai versus Republic. It's a 2012 case. I think it was case number 16 of 2012. Justice Korir also said it is not only necessary perhaps to put a person in custody, but also to ensure that you put terms and stringent terms so that the person can be able to comply. And if then we are be able to convince you that you can grant bail to them or to the accused person, please, Your Honor, we are asking again, can the terms be the ones that the accused person can be able to meet? The state would want, of course, to respond and tell you that you have ruled about this matter and you have already given terms and that maybe probably we should appeal, or that the court has made a ruling. But the law allows us to review. Your Honor, I believe had this matter probably been handled in a better way, and I'm not saying that maybe it has been handled badly by previous counsel, probably would have been able to convince you that the steps taken by the state were not convincing enough, they were not compelling reasons. That she failed to bring her medical documents and all those things is not a compelling reason. It only shows that maybe she was ignorant, and that's not an excuse. She should have provided. Then I will stretch our hands and touch your heart, and hope that the eyes now that you look at the accused person with are different now. Can it be with a humane heart? Can it be that because we have come here and we are also saying now, Your Honor, the accused person is sorry, and she's asking for leniency. She is sorry. And that word by itself, if it touches your heart, it goes a mile. It goes a mile. Can the court forgive? I believe so. It is what we want. It is what we hope. And by the end of the day, it is what we expect. Allow Your Honor to go back and see her child, take care of the child, take care of whatever business she can manage. She will come back to court. That is all I wish to state, Your Honor.